Item number 1.
Hey, this basically is against the implement order of the London Single Judge dated 27/6/23, whereby my writ petition was dismissed by that, wherein I had challenged the rejection of my bill on the ground that it could not be opened on the date of opening of the price bill due to lack of login credential. On this ground, it was rejected. This was challenged before the learned single judge. However, it was held that there is no unfairness in doing so, and accordingly held to be correct. Now, my case before your lordship is like this. As per the NIT, there is an obligation asked on the respondent authority to open the price. Now, the opening on that day was basically it is automatically there is an opening and a system generates and who is the L1 bidder. That is provisional. I will show it from the terms of the NIT. Now the learned single judge, with utmost respect, have held that to be final, which is against the terms of the contract. I will show this to your lordship. Now, before I take your lordships, I may just indicate few important dates. They can see this is otherwise a useful center for the development of reactors and regenerators in the NRL expansion project. And the two-bit system, the dates which are relevant, your lordship may kindly take a note, is that the last date of submitting bid was on 7/12/22. On which date we have submitted the bid. Both the it's a two bid, so both techno-commercial bid as well as the price bid. This was submitted on 7/12/20. Then the techno-commercial bid was opened on 24/12/20. We have been, in fact, there were only two bidders, and both the bidders were techno-commercially qualified. We have received the intimation, which your lordship, since I filed at page 182. Your lordship may kindly have 182 for a moment. As your lordship got page 182, your lordship will find summary sheet and serial number 5 with acceptability status. Your lordship will be referable below. Then the name of bidder, serial number 1 is the respondent number 4, serial number 2 is the petitioner with your lordships. Then at page 183, your lordship will find where the financial bid was opened on 26/12/20. Your lordship will kindly see bids, serial number 1, R4, serial number 2, the petitioner status admitted for bid opening, financial bid opening. So I was qualified to be opened. The date your lordship will find 26/12/22. Now, my lord, interestingly, what happened is that, in fact, unfortunately, what happened on 26/12, when the bids were opened, for some reason, in fact, for a technical glitch, my bid couldn't be opened. Therefore, and what happens is that automatically a system generates the DOQ comparative chart, wherein the L1 bidder provisionally is shown, which emerged out on the basis of the prices quoted. Provisionally, it is shown as L1 bidder. Now that QR comparative chart, your lordship will kindly find at page 185. We are also providing the clear version of the same.
Yes. $185.
185. I'm sorry, but it is not very clear because this is how it was in fact available. In fact, in the judgment also it is not very legible. Here your lordship will kindly see on top. It says L1 amount, L1 bidder, vendor. Sorry. Then your lordship will kindly see at the last page towards the bottom, lowest amount quoted by your lordship will find hardcore rate. Now, this is the QR comparative chart which the system generates. I will show that relevant clause, which is F1TT. This is a very provisional thing. I will show that. Now, since on 26 they could not open, on 27, in terms of the NIT, they started communicating with us.
This is for the respondent.
Because my lord, on 26, they could not open my price bill.
Hmm. So what was
Therefore-
reflected? What was reflected in the screen?
My lord.
What was reflected in the screen?
Yes,
What was reflected insofar as your bids are concerned?
or only the name of the respondent number 4, my lord. Because what happened, 2 price bids were supposed to be opened. Now, when the system was opening the price bid, they could only open the price bid of respondent number 4. They could not open the price bid of respondent number 3.
All right.
Therefore, the automatic QR comparative chart could only take the price of R4 and did not take ours. And accordingly, they have set L1 bidder is R4. Now, this is provisional and I will show that. Now, thereafter, your lordship may kindly come to page 186. Now, these are the communications which we received. Your lordship may come first to page 187 towards the bottom. This was an email which we had received on 27, that is on the very next day, at about 12:18. Your lordship may kindly take note of the date and the time. It is given at the last email at page 187. The contents, if I may just take your lordship through, while opening your price bid, your lordship will kindly see BOQ Excel file. Why I am emphasizing this? Because this is the file and format in which I have to submit my price bid. So there is nothing wrong in the file or format. It is mentioned BOQ Excel file for tender reference so and so for the supply of so and so. It was found that the Excel file is not opening. You are requested to analyze and revert on how the price BOQ file can be opened to view the contents. During our attempt to open the file, it is found to be seeking login credential. However, please note that the above request to enable opening of the price BOQ file must not be constituted in any way to mean that the prices and or your offer will be used for further bid evaluation. Further bid evaluation is any shall be subject to the terms and conditions of the tender and applicable law. NRL reserves the right to reject your offer in accordance with tender provision and applicable law. Now, in response to this, we replied. Now, your lordship might see the mail which is just on top of this particular email and the same page. This is the same date at about 14:20. We write to them. It is surprising to note that the Excel file is not opening. We are able to open the same in our system without any issue or problem. In case it is asking for the login credentials for opening in your system, you may please use the email ID tender so and so as the login name. Password for the email ID is so and so. We hope you will find the above in order. Then again, now if you're logically go back to page 186. The last mail there, my lord. This is at about 4:46. This is again from them, where they say we are still unable to open the file even now, sharing below screenshot for your information. Then on top of your lordship, is the 4th email which we write, which is at about 5:43 of the same day. We checked again with our IT team, who have confirmed that with the login credentials given to you, the document should open in your system as well. You may like to check with your IT team if there is some issue to be resolved in your system, which is prevailing the file to open. Alternatively, you may also check the status of document opening the NRL if they are able to open the document in the system and share the same with you. Now, if your lordship kindly come to page 208, here from this is the affidavit that they have filed. From here, I just want to show that ultimately on 27 itself, they could view. This they have admitted here at page 208, paragraph 7, as your lordship got it. Page
Yes.
208 is the affidavit filed by respondent number 2, at para 7. There's a lot of problem.
Yes.
Para 7. That the respondent number 2 states that being able to view the price bid of the petitioner on 27/12/22. That is a day after the scheduled date of opening of price bid. Now, I'm just for the moment, I'm only showing it that it's admitted that on 27 they could view the file. Now, if your lordship kindly come back. But thereafter.
What was the date for opening the price bid?
26.
26.
26. That, however, I will show your lordship from the terms of the contract itself that they can seek for clarification, and that on that opening, the price bid actually ultimately is a provisional exercise. I will show all that, but just before that, your lordship may kindly come to page 71. Ultimately, on second,
71.
page 70. This is the impugned order,
Yes.
the letter. Because after 27, there is no communication with us. We don't know what has happened. On 2nd January 23, we received this letter. The lordship will kindly see the content. We regret to inform you that your price bid amount cannot be considered for further evaluation, as the contents of the price bid are not viewable without login credentials.
Then this was sent on?
1 second, your lordship will get the date on top Monday, and your lordship got that Monday, January 2, 2023 at about 10 p.m.
Yes.
As such, if I may just continue reading, madam.
Yes.
As such, your offer stands rejected in accordance with clause F1A, read with F1BBB of the notice inviting tender of the bidding document for reactors and regenerators package and applicable law, including law of equity. So they have said that we could not open it on 26 because of lack of login credentials, and therefore the bid stands rejected in terms of F1H, which I will show is not applicable, read with F1BBB, which is also not applicable. Now, before I take your lordship to that, those two particular clauses, I may just point out few of the important relevant clauses from the NIT matter. Your lordship will find the NIT at page 83, which is dated 25/10/23.
Yes. Page number?
Page number 85. Sorry, 83. 83 it starts, the NIT.
No, the relevant clauses.
First, your lordship will kindly see clause 106, which is page 106. This is just to show how the bid has to be submitted. This is clause 12, mode of submission. Bid must be uploaded to portal before the last date and time of submission of the tender. Bid submitted using any other mode will not be accepted. Now, there is no quarrel to this that I have missed the submission date. As I have pointed out, I have submitted my price, technical and my price bid on the dates on which I have on the last date, my lord, which is 7th of December 22, in the prescribed manner. And in fact, my lord, there is also a clarification which they had asked, where it has been cleared, in fact, they have admitted that once the price bid is submitted, I cannot modify. No one can modify. It will stand as it is. Now, your lordship will kindly come to page 110. This is part of clause F, which actually starts at page 109. Your lordship will get F general at page 109. Then, if your lordship kindly come to 110, your lordship will get F1, which is leading document. As your lordship got that?
Yes.
F1, leading document. Now, from here, if your lordship will kindly see clause E, both techno-commercial bid and price bid are to be submitted concurrently, duly digitally signed at the e-procurement portal. Then 111, which is H. Now, this is one of the clause which they rely to reject my bid. May I just read H, my lord? At page 111. In order to maintain confidentiality of all documents and drawings submitted by bidder in response to its unpriced bid only, Reader shall upload password protected PDF files only in the portal for each same password shall be used for all uploaded PDF documents, which will be subsequently shared by email to the officials of NRL as per the details mentioned at serial number 20. Now, if your lordship kindly note, here they are only talking about unpriced bits. It says that unpriced bits should be password protected.
What is an unpriced bid?
And a technical.
Okay.
When they are submitting when we submit a technical bit, there are a lot of documents, drawings, IT returns, a lot of certificates be enclosed. So all this should be password protected. This is what H says. Now H does not even indicate that in case of a price bid, if you give it in a password encrypted form, it shall be rejected. This is not there. It only says that in case of unpriced bid, you must give a password protected PDF file. However, saying so, my lord, it is not my case that our price bid was password protected. I will indicate what has happened, but it was not password protected. Now they rely on H and say, no, password protected is only for unpriced bid. Therefore, since we could not open your price bid because of login credentials not being there, therefore we are rejected. This is one of the arguments. Am I clear, my lord? Now, as for H, it is only in respect of unpriced. Then your lordship kindly come to page 112. X. During the tendering stage, all communications will be made through e-procurement portal. However, post submission of bids, all communication, your lordship will kindly see, stroke clarification shall be sought outside the e-procurement portal. The scope of clarification.
Where is the clause for the price bid?
My lord.
Where is the clause for the price bid?
My lord,
You have referred to.
CTP, I will come there, my lord.
Yeah.
I'm just taking it one by one so that I don't have to trouble your lordships in going back to the pages. Clause 10 has your lordship got it. That speaks about clarification post submission of bid. The lordship has got it. Which they actually sought on 27, after they could not open my price. Now your lordship will kindly come to page 114. This is the price bid release. The query that just came from your lordship. This is clause F1TT, the most important clause. May I please?
F1.
F1TT at page 114.
This will be immediately after double S.
Yes, yes.
Okay, it's not very clear here.
I'm sorry, but I'm.
No, doesn't matter. Doesn't matter. We're just confirming it. We're just confirming it. It's immediately after double S.
After the S.
Yeah.
May I read it?
Yes, please.
Readers to note that the comparative statement within bracket your lordship will see BOQ comparative chart. This is that chart which I had shown you. Generated after opening of the price bids is system generated. Your lordship will kindly take note of this. Is system generated and may not take into consideration of various loading and evaluation criteria as defined in the bid document. It is very clear, my lord, that on that day, on 26th, the BOQ comparative chart is system generated and does not take into account the various loading and evaluation criteria, and therefore is only provisional. Now the sub-para will make that more clear. The actual comparative tabulation within bracket in PDF format, considering all loading and evaluation parameters of the tender for techno-commercially acceptable offers will be uploaded on CPP portal by the tender inviting authority after opening of price bids, and the same shall be considered as final. It's very clear, whether there's no scope of any ambiguity here, that after provisionally, after the automatic opening, they are obliged to open the price bid manually, evaluate it, and then put it in a tabulation sheet and upload it in a PDF format in the CPP portal. That is the final one. And with utmost respect, my lord, subject to correction from the other side, we checked the CPP portal the other day, and till date that has not been done. And in fact, nowhere in the affidavits they have said anything about these post evaluations, tabulations, and uploading. And Learned judge, single judge.
No, no, how are you to upload? How do you upload the price bids? These are all on the e-portal.
Yes, madam.
Like, so something happened that it required a password,
Not pass, well, a login credential.
login credential.
Alert your lordships, sometimes even when we receive emails, sometimes the attached document doesn't open. Like a bank statement.
Hmm.
Now, these are not, sometimes it happens, a lot of time I also face this issue. Now, this is from the CPP portal, which we have, I have instructions that my client has checked. If your lordship kindly see towards the end, the financial thing, there is no tick mark.
Yes,
Your lordship kindly see in process 2, financial bid opening, your lordship sees the status, tick mark. Then your lordship will find financial evaluation, kindly see the status. There is no tick mark shown. So we don't know what has happened.
this is on which date?
This week, day before yesterday, they have visited the CPT portal, madam. This is the, so I don't know, I'm sure the authorities would explain
Yes,
when they have made it final. Because why I am on this slot, my lord, I will take your lordship to that particular paragraph of the letter single judge, where the letter single judge says that my state was sealed on 26th by a computer automatically. The moment they emerged as L1. But now, if your lordship kindly see the last paragraph in T, which is also very important. Kindly see the last paragraph. May I read it, my lord?
yes,
Readers to note that no contractual obligation or complaint whatsoever shall be entertained against the system generated EOQ comparative chart. Now here, your lordship will find there 2 words. The first one says no contractual obligation, which means that on 26/12, when this BOQ comparative chart, the L1 is declared, that particular L1 will have no rights. No rights will accrue to him or to the entity, because that is only an automatic exercise. The rights will come in after the finalization and after it is put in the CPP portal. There is a process, and in fact, the manner.
this goes both ways. This can be interpreted both ways. Not to have any contractual obligation can be interpreted both ways.
To me, my lord, as of now, the word contractual obligation comes very important, because there can be a situation on 26, a particular, suppose in case of price bids of 1 to A and B. Now, on that day, the price of A is shown to be lower, but after the evaluation is completed in the manner prescribed and taking the loading parameter, B emerges as L1 here. It happens. Then L1 cannot come in and say, no. On 26 in the BOQ comparative chart, I was declared as L1.
All right.
Now,
Then-
why am I emphasizing this? Because the learned single judge.
So your case essentially is on 26th when the price bid was opened or attempted to be opened, what was actually available was the computer generated BOQ.
Correct.
So there was no evaluation
Absolutely.
in terms of the contract.
Absolutely.
To arrive at a finding would be the L1.
Absolutely.
That's
And
your
in fact,
case.
the next particular.
But you don't dispute the fact that on 26th, your price bid could not be opened.
It could not be. I'm just taking a few more clauses, then the whole.
What
thing-
are the clauses with regard to specifications
Yes, I'm coming to that.
after
Evaluation.
after you open
Yes,
the,
but I'll come to the evaluation part.
yeah,
Before that, your lordship will kindly come to 115 for a minute,
yes,
because this is that F1 triple B. Your lordship recollect, they have taken this into account while rejecting my. Now, your lordship will kindly see, readers to ensure submission of correct file format in the portal in case NRL cannot open the reader page due to, your lordship will kindly see, due to corrupt big files. So format, the offer shall be rejected. So one of the ground of rejection is if the file or the format is corrupted, and because it is corrupted, they cannot open. Then the bid will stand of reject. Am I clear, my lord? This only talks about a corrupt file or corrupt format. And how the
And is it defined anywhere? What is ORAF file?
well, that is not defined, but if your lordship kindly come to triple A, there's the clause on top. Your
Hmm.
lordship will kindly see how, what is the format that they have given. The bidder shall adhere to the following provisions of the bidding document without taking any deviation. Failing which the bid shall be considered to be non-responsive and are liable to be rejected. D, it says price BOQ format. So the price bid, it has to be in a BOQ format. Now this format, I am told, is given by them itself. What I have to do, my lord, is download the BOQ format. Then fill up the details, the price details, whether those will be gaps, mine. I just have to fill it up. After filling it up, I have to upload this very document. I cannot change the format. The lordship knows format is setting up. The format, if I change or I modify, I am out. It will not be accepted. And similarly, my lord, after I finish the exercise, for some reason, if this file becomes corrupted, your lordship knows corrupted is because for no reason, it will just it will be impossible for one to open it on that day. That is corrupt. It does.
Where is the provision? Where is the provision to say that it will be downloaded and filled up by hand?
Yes, there is. Yes, that your lordship will kind take 166, which is the instructions to online page. Kindly see page 166.
Yes,
May I just read it, my lord?
yes,
This is publication of rates.
yes.
Bidders are requested to note that they should necessarily submit their financial bid in the format provided, and no other format is accepted. If the price bids have been given as standard BOQ format with the tender document, then the same is to be downloaded. Your lordship will get that. Downloaded and be filled up by all the bidders. Bidders are required to download the BOQ file, open it, complete the white-collar unprotected cells with their respective financial codes and other details, such as name of the bid. No other cells should be changed. Once the details have been completed, the bidder should save it and submit it online without changing the file name. If the BOQ file is found to be modified by the bidder, the bid will be rejected. So it's just the format. Then even down, if your lordship kindly see the last paragraph, the uploaded tender documents become readable only after the tender opening by the authorized bid openers, not before that. So what I am trying to impress your lordship upon is that the format is given. I cannot change this format. However, the letter single judge said that I have modified it. That is an error of utmost respect, is an error of finding. Because I cannot modify this format. If I have modified, it will not open. But here, this is not the case. They could ultimately open it. The only problem was that it went in a protected code for which on that particular day it was not opening. After putting the login credentials, it opened. I have not even encrypted the password. Though there is no bar under the NIT, but I have not even done that. But anyway, my lord, just I also want to draw your lordship's attention to the evaluation procedure, because that way I will complete the 153 if your lordship kindly come for a moment. Because these are all detailed. It's absolute go by to all this.
So what is the status now, Mr. Dekar?
Well, the LOA,
Work has been allotted, ma'am.
in fact, this was allotted when the judgment was, when it was reserved for judgment. At that time, we had approached the learned single judge by way of an interrogatory application. And the learned judge was pleased to stay further proceedings in terms of the LOA. However, when on 27, the final judgment came, which is against us. Therefore, the urgency and therefore we are.
So all the parties are represented,
R4 is represented.
R4 and R3.
R3 is the
The
reading.
consultant, R3 is the consultant.
R3 is basically their reading agent who done on the
Okay.
exercise on behalf of NI.
All right. So they have not started on the work.
They have started the work.
They started the work.
The issue is this, my lord, the
Ah.
project is the Numaligarh refinery expansion project.
Whatever it is,
My lord, it has been postponed from January till June, we are in June. My lord.
the issue is not that. The issue is that there was something happened, you could not open their price bid.
And I'll show that, come, Lordship, give me, my lord, let us conclude and I'll show that.
All right, we'll hear him then. Yes.
Hearing.
So 153, that is the evaluation thing, how is it to be done? So Lordship will kindly for a moment take it. I'm sorry, we are troubling your Lordship on a vacation time.
No, judges don't have vacation, don't worry.
Page 150, at page 152, your Lordship will
Yes.
opening of price bid. This is clause 41, and your Lordship got it.
Hmm.
Opening of price bid, your Lordship got it. Price bid of only those bidders, your Lordship will kindly see of those bidders whose techno commercial bids are determined to be technically and commercially acceptable by NRL consultant shall be opened. Now here there is no dispute to that. I have already shown that I'm techno commercially qualified. Bidder selected or opening of the price bid shall be informed about the date which we were informed. Then your Lordship will kindly turn the page and see page 42. In fact, correction of arithmetical errors is also given. Your Lordship will kindly see this is after the price bid is opened. There is a reason why I am showing this clause, my lord. Kindly see where bidders have been asked to quote unit rates based on SP form. The prices quoted by the bidders shall be checked for arithmetic correction if any, based on rate and amount filled by the bidder in S1 SP form format. In the event of any discrepancy between the rate amount provided by the bidder in figure and word, the rate amount provided in words shall prevail. Also, in case of difference in lump sum price versus in breakup provisions defined in the schedule of rates, preamble to schedule of rates shall prevail. Bidders shall be requested to accept, the documentary bidders shall be requested to accept correction or arithmetical errors of the price bid. Failure to accept the correction in accordance with clause 34.1 of ITB shall result in the rejection of the bid and bid security shall be forfeited. Well, the reason why I'm showing this clause to your lordship is that because one of the finding of the learned single judge that my fate was still on 26/12, which is not correct, my lord, with utmost respect, because once they open manually the price bid and they find that there is some arithmetical errors, then they can seek clarification and correct it. So once that is done, automatically there could be some change in the TOQ comparative chart. Obvious, there could be. So it doesn't mean that once a particular bidder emerges as the L1, it is provisional system generated BOQ comparative chart, everything is safe. That is absolutely a fallacy. Then your lordship will kindly come to clause 43, which is most important. This is evaluation and comparison of price bids. The consultant shall compare the price bids based on the evaluation methodology and loading criteria. And this is given at page 154, which that's 164. Provided in EPS to determine the bidder with the lowest evaluated price bid. And in fact, it is defined that L1 means the lowest evaluated price bid, not someone which emerges. That definition your lordship will find at page. At page 122. L1 is defined. This is part of the ITB. The lordship may just take a note. Page 122. L1 bidder shall have the meaning as set out in clause 43 of ITB, page 153. That means lowest evaluated bidder. Now, the lordship will kindly come to page 164. Thereafter, page 154 is award of price bidder that your lordship will see. Subject to clause 46. Shall award the contract to L1 bidder who has been determined to be the lowest evaluated price bid in terms of ITB clause 43 above. This exercise has to be carried out. And if it is manual, then your lordship will kindly come to page 164.
No, from where do you say this evaluation part? Where is it mentioned? What is the process for
If
evaluation?
your lordship has a moment, then your lordship will get, I think I will meet your lordship's query at page 164. The evaluation and comparison of which shall be carried out as per the column. The manner is provided at page 164. Has your lordship got that?
Yes.
This is the manner in which the evaluation has to be carried by NR. So what clause 153 says is that based on the evaluation.
So are you saying that notwithstanding your file not being able to be digitally open, there is still a responsibility to
Absolutely,
evaluate your price?
absolutely.
How?
Why not? Because it mentioned that.
Your price has been digitally uploaded.
And techno commercial are qualified number one.
No, you are correct, but your price is also digitally uploaded,
Yes, my lord.
but that could not be opened.
My lord, not because, my lord, it was because of a corrupt file or
Whatever,
anything.
Whatever the reason may be, but it could not be opened.
Now, if they could have opened both the price page, it would have ultimately in the interest of public interest, my lord.
What
Because
I'm
it's
trying
how
to
it's-
understand, kindly listen to the court. What I'm trying to understand is, this is not a case where you upload bids digitally and also give physical bids in the physical form. This is only digital. So you digitally upload your techno-commercial bid. You are found to be responsive. Your price bids were sought to be open, but it could not be open. Whatever the reason, your fault, their fault, somebody else's fault, it could not be open. Now, under the circumstances, how will the employer evaluate your bids, which is digitally uploaded and could not be open? On what basis?
My lord, to answer your lordship's query, first of all, my lord, in the NIT itself, they have indicated that for reasons for which if they cannot open the price bid will still reject. My lord, they have indicated that. Now, my case doesn't fall there, with utmost respect, my lord, because that clause talks about corrupt file and corrupt format.
So now we have to
That is
decide
not my case.
whether the failure to open, the failure of the files to be opened will amount to corrupt files.
My lord, that they have, because my lord, in paragraph 2, right, paragraph 7 in their affidavit, they don't say that. They said they opened it on 27. So, and in fact, on the second day, when the matter was remanded back to the learned secretary by the appellate court, there is a clear categorical admission from my learned friend that they have opened it. And in fact, based on that, before the remand, when the matter was taken up on 6th of January by the single judge, a categorical government statement was made before the honorable single judge. In fact, I can read it, that is 193. The counsel for R2, it will suffice to record herein that on appointed query of the court upon instruction, the learned counsel for R2 has submitted that he has received instruction to the effect that the price bid of the petitioner could be opened after receipt of the password from the petitioner. Therefore, my case is for a corrupt file format, and they agree to it. In fact, based on this submission, the learned single judge said that since now you have opened it, you consider. But this was carried by way of an appeal by respondent number 4, because on that day the respondent number 4 was not there. They were not heard, and therefore the matter was remanded back to be heard by the learned single judge. In fact, state no file comes reviewed, but they never appealed against that. Now, yes.
Yes.
So your lordship have already seen the evaluation and the manner which the evaluation is done. If two more documents, and then I may expect if the lordship to be included that way. If the lordship.
We are not disposing of your appeal today.
No, my lord.
So therefore, we just wanted to understand the basic grievance that you have.
Two things, my lord, and I won't trouble more, my lord, because these are if they have frequently asked questions, they have mentioned that sometimes it may happen and they can ask for clarification. These are also there. So it's evidently
No,
there.
that is presupposing that your the bids in the digital form can be capable of being opened or downloaded or read or something like that. But here is a case where your files could not be opened.
But only on 26.
Correct.
On
the date.
My lord, your lordship will kindly see the significance of that.
That is the date mentioned in the NIT.
Symbolic, because after that date, nobody can submit a price bill. That is why, because nobody can change it. Now here, if for a moment, if
Subsequently, when was it opened?
On 27, as per their affidavit, I have already shown that, my lord.
So according to you, when they have subsequently opened it, it was their responsibility to now go for evaluation.
Absolutely. And your lordship will take into account that it was they who communicated to us and said, they are not being able to open. give us the login credentials, we give it to them. And this they done as per the powers under the NIT. They cannot now adopt a hyper-technical approach and reject us. That would lack fairness and arbitrariness. Well, it will be arbitrariness. It will lack fairness and reasonableness.
All right, let us,
The very fact that they
let
took
us-
a U-turn, it shows that they are trying to favor someone.
let us hear
But
them.
it's two paragraphs from the
Yeah.
judgment.
Yes, yes.
Your Lordship, we kindly have page 403.
40.
403.
Yeah, you can refer to the paragraphs of the judgment.
Paragraph is 19.1.
19.1.
Let me not, your Lordship may directly come to 404.
Paragraph
Paragraph 19.4. Page
19.4. Yeah. Yes.
At
Yes.
page 404, your Lordship will see that the DOQ comparative chart which I have shown to your Lordship is reproduced. Has your Lordship got that?
And your reference is at the table below,
Yes, yes,
where only the name is reflected.
L1. Yes. Now kindly see 19.4. From a look, may I read it, madam?
Yes.
From a look at the above system generated BOQ comparative statement, it is evident that the BOQ comparative statement had only reflected the data and the rates from the price bid in BOQ Excel file format uploaded by ART4. Though the petitioner has also claimed that it has uploaded the BOQ Excel file containing its price bid successfully on the e-procurement portal, the BOQ comparative statement automatically generated on 26/12/22 did not reflect the data and the rates submitted by the petitioner for its price bid in BOQ Excel file format. In fact, the system generated BOQ comparative statement was blank insofar as the data and the rates of the price bid of the petitioner were concerned. It is pertinent to mention that the system in the e-procurement portal automatically generates the BOQ comparative statement without any manual intervention. The court is privy to this. One more look at the automatically generated BOQ comparative statement goes to show that the R4 was declared as the L1 vendor therein on 26/12/22 itself by showing so and so as L1 amount. This is very important, my lord. Thus, it is evidently clear that it was on 26/12/22 itself. The R4 was declared as L1 vendor in automatically generated BOQ comparative statement created on the e-procurement portal at 3:48 p.m. From that moment, 3:48 p.m. onward, a distinction was made between the petitioner and the R4, with the R4 having emerged as the L1 vendor and the petitioner being mentioned as the one whose price bid has suffered from defects. Now 407, page 407.
Yes.
What has emerged in clear terms, paragraph 22, the last paragraph.
Yes.
What has emerged in clear terms from the above exchange of communications between the parties is that the petitioner has put a password in the BOQ Excel file containing its price bid. Look, this may not be so much relevant. Your Lordship may come to 409 at page 25.
Para.
All right, sorry, but 408,
Paragraph
paragraph 20.
23.
20.
Yes.
In view of such fact, situation obtaining in the case, this court is of the unhesitant view, as your Lordship got that the aforementioned communication exchange between the parties took place at the stage of post invalidation of the price bid of the petitioner with the R4 already identified as L1 vendor by the system generated BOQ comparative statement created and uploaded on the e-procurement portal on 26/12/22 without any manual intervention. This is absolutely against the contract terms of the NIT. Now kindly see at 409 clause 25. Clause 25, paragraph 25, the beginning refers to clause F1 is that the Lordship is not looking now. The last line your Lordship will see by clause. I'm just trying to show the finding on F1B. There's your Lordship for the last word by clause and then page 10. By clause FTT. Readers were made aware that the comparative statement generated after opening of the price bid which is system generated. Now here your Lordship will see and no complaint whatsoever shall be entertained. While the single judge, learned single judge took note of the complaint part, but has failed to take note of no contractual obligation. That was missing. Now then, your lordship will kindly see the last about 5 lines from the top in clause 37 of part 5 of the ITP. It has been stipulated that a substantially responsive EB would be one which would meet the requirement of the bidding document without deviation. With a price bid in BOQ Excel file format with password given by the petitioner itself denying access of its contents to others, including the tendering authority, the price bid uploaded on the e-procurement portal was clearly with deviation and therefore its declaration as non-responsive cannot be faulted with appendix A of the ITB that specifically set forth the condition that if the BOQ file was found to be modified, the bid will be rejected. So the learned single judge ultimately said that I have modified it. It is impossible, madam. I cannot modify it. That is not the case. The case is simple, they could not open it. And that is not a ground of rejection. I don't want to cover your lordship right now with various case laws. Your lordship is aware of all the various case laws in the field.
Let us hear what they have to say.
See your lordship and such industry where they say sometimes the essential conditions are there and ancillary. Of course, there is some mistake in
What is the essence of this system generated BOQ?
that is because automatically it discloses to the public that yes.
Let me rephrase the question.
It only or it gives an.
It is a tender condition.
Correct.
Now, what is the meaning that you would like to ascribe to this particular condition, particular clause?
But it has to have some significance, otherwise it will not be very penalty. But according to me, my lord, it is to give the public an idea that on that day, this is how the L1 has emerged. They have received 2 prices or they have received 3 price bids, 4 price bids open, and out of the 4 price bids, who is L1? This is great, but this is lordship will ultimately see this is only probation. This is not conclusion. This is not post-evaluation. This is pre-evaluation. After this is done,
Let us
on the authorities
let us see
now
the-
to open the price bids.
let us see the clause for evaluation again, once again.
Yes, my lord. Page 114. No,
114.
Oh, no, evaluation. Your lordship wants to see the TD clause, my lord, or the evaluation?
No, evaluation.
Yeah. Evaluation, your lordship comes to 153.
Yes, evaluation of price bids.
Yes. The consultant shall compare the price bids based on the evaluation methodology.
Where is that methodology?
Page 164.
164.
This has to be done manually. After the opening. And for all techno-commercial bids. Now, if for some reason my bid could not be open on that day because of the reasons mentioned in the NIP, for which I may be rejected, that is a different case. But since on the subsequent day it could be opened.
Now,
and I
these
cannot modify the
price bids are available where? These price bids, page 153.
Well, in the CPP portal, I am told, madam. Right. Well, what happens, madam, in the CPP portal, madam, is on the opening day, it will open, madam. Now, after opening, system will automatically generate and prepare the.
And then you make a
chart.
evaluation.
That is automatic. After that, they have to do a manual evaluation. That
I
has
know
to be done.
this manual evaluation will be based on the print with the prints which are received from the portal.
Absolutely. Now, this they could open on the next day. After they ask for the login credentials. This is what I'm trying to say before your lordship, my lord. It is they who ask for my credentials and then they give it up. Now, here, one very important fact I have just forgotten, my lord, from the additional affidavit that they have filed. Page 219. Just one thing, my lord, and then I will.
Yes.
219, there is an additional affidavit which was filed by R2. Now, here, your lordship will kindly come to page 222. Paragraph 4. Page 222, paragraph 4. This is the additional affidavit filed by R2. There's one thing I would like to point out.
Hmm.
May I read it, Madam?
Yes,
That the IEMs were of the view that the petitioner had made a serious mistake by submitting a password protected file. It was further observed that the tender provisions make it clear that in case of the bid other than the unpriced bid is in different format, encrypted or password protected format and cannot be opened, is liable for rejection. Nowhere, my lord, I have taken your lordship extensively through the NIT, nowhere it says that. This is something they're inferring. Then your lordship will kindly see, and since the price bid of the petitioner could not be viewed on the date of opening of price bid, their offer cannot be considered for further evaluation, and their offer is liable for rejection. Now, this is very important. It is stated here that the NRL management has duly taken into consideration the aforesaid observations of the IEL while rejecting the price bid of the petitioner. Your lordship would recollect, my rejection was on 2nd of January. Now, this observation, your lordship will kindly find at page 224. Your lordship, for a moment, will kindly come to page 227, the last page of this my news. Your lordship will kindly see it is digitally signed on 4th of January 23, after issuing the rejection letter. And in their affidavit, they are saying by relying on this my news, they have rejected me. The entire Usher's banner is absolutely clear, my lord. They are relying on this, which is signed. Your lordship will kindly see the date. This is their officer. Kindly see the date. 2023.1.4, 4th January 23. And my rejection letter at page 71, your lordship has seen, is of 2nd January. And the stand taken in the additional affidavit is after considering this observation, which is unsigned on 2nd. It was only signed on 4th. But arbitrage is writ large in this case, my lord. Because they themselves have sought for the credential, login credential. Suddenly they gave it up. And they opened it. It is not a case that they still couldn't open it. They admit. They have in fact made a statement before this honorable court that they could subsequently open it. And from their affidavit, it is written that on the very next day they have opened it. And your lordship will kindly see clause F1TT, your lordship recollect. It makes 3 stages. First stage, POQ, which is system generated. Thereafter, the obligation is to manually open and look into everything as per the evaluation methodology given in the NIT. And then they are required to upload it in a PDF format in the CPP portal, which still they have not done. And that would be conclusive and final. And the learned single judge have held the POQ on 26 to be final, which is absolutely wrong on the face of it. This court cannot interpret the terms of
okay,
the contract.
let us see it.
Very
Let
well.
us see it. Yes,
Let us first understand the tender procedure.
please do.
Page 111, unfortunately.
Hmm.
It's a two-bid system of techno-commercial bid and the price bid.
Yes,
You are required to file your techno-commercial bid, that is the technical bid, along with all the documents, drawings, etc. Now, 111 clause F1H, my learned friend has read. In order to maintain the confidentiality of all documents and drawings submitted by bidder in response to its unpriced bids, only. Should be kindly note the word only. So only in respect of those documents which are submitted along with the unpriced bid, you are required to put a password. Lordship reads further, the bidder shall upload password protected PDF files only in the portal. Now, Lordship will kindly understand the procedure now. Everything takes place on the portal now. What my learned friend is submitting about regarding the manual evaluation now, that is post opening of the price bid now. Let us not put the cart before the horse now. Only when we receive the bids are opened in the portal. Only when we download the figures, then we will evaluate manually. The question of now preparing a comparative statement does not arise because it is only the sole bidder now. His bid is no longer there now. Where is the question of preparing a comparative statement now?
then why did you ask for the passwords?
That we have asked for the password, but that was not opened in the portal. Lordship will kindly read my affidavit.
Then something was mentioned in your affidavit that it was,
Yes, no, it was
Open.
not opened in the portal.
then,
It is still not open in the portal. It does not open in the portal
then how did you view their prices?
because we downloaded the file,
You downloaded it?
the PDF, the Excel file.
No.
The system is like this. You have to upload the PDF files with regard to the technical business. The price bid is an Excel file, which you have to download. The bidder has to download, he has to fill up his figures and upload it. Now, while uploading it, he puts a password. System is that
Which is known to him only.
which is known to him. System is that, madam. On the date and time fixed for price bid opening, without any manual intervention, madam, the price bids will be opened by the system. And the system itself will create a comparative chart.
Hmm.
That L1, I am agreeable, madam, that L1 is not the final level. It is subject to further evaluation, but that is after receipt of the price bids, madam. When we cannot open the price bids, our interpretation that it is a corrupt file, madam, has to be accepted.
No, but then why did you open the five price bid up
We
and
opened
down?
it subsequently in our own system.
Why?
We that with a rider that with a caveat that the rider signature is there with it. Because with a caveat that though we are opening it, it is does not amount to acceptance of your.
Why did you open it? If
It is still not-
if it is your case that it doesn't open in the portal
It doesn't.
and therefore its price bids are rejected,
Reject.
the end of the story.
It
Where
was
is the occasion to
But now
download and
even-
open it?
even today, madam, the private respondent cannot view the price.
All right.
On the portal, the private respondent cannot view the full price. Bid. Lordship will kindly come to that clause, madam. Page 166.
Yes.
Because now my undertone is submitting, madam, subject to correction that there was no password put, it was only asking for a login credential, madam. But it is an admitted position. Where before the single judge, madam. the
Page
senior counsel had admitted
166.
166.
Yes.
Bidders are requested to note that they should necessarily submit their financial bids in the format provided and no other format is accepted.
What is the format?
Format is the BOQ Excel file, madam.
Hmm.
If the price bids have been given as a standard BOQ format with the tender document, then the same is to be downloaded and to be filled by all the bidders. Bidders are required to download the BOQ file, open it and complete the white colored unprotected cells with their respective financial codes and other details such as the name of the bidder. No other cells should be changed. Once the details have been completed, the bidder should save it and submit it online without changing the file name. If the BOQ is found to be modified by the bidder, the bid will be rejected. So, my lord, you are required to download the file, fill up the gaps, upload it. The moment you put a password, my lord, you modify the file.
That is little
So, because we cannot
extended
do it,
interpretation.
and that is cannot.
Format would be the format that is available in the web.
My lord,
Format is the format which is available in the portal.
yes, but you are not supposed to tinker with it. Lordship will again come the next page, madam. 167,
Hmm.
fourth point from the bottom.
But then you can reject a file only if it is corrupt. Do you say it is corrupt?
But if it cannot be opened in the portal, madam, it is corrupt.
That's a different issue. How do you say that it is corrupt?
It is corrupt, madam, because we cannot. open
Under
it.
what definition? Where is the definition of corrupt?
Some free play in the joints has to be given to us, madam.
No, correct.
The document, madam.
There is absolute free play in the joins. But the
Madam.
question is, why did you ask for the password and why did you download and reopen it? And then
We
you-
did
then
that,
you-
madam.
then you
We
rejected
did
it.
that. We did that, admittedly we did that. madam.
Then-
Definitely not, I'm not accepting it, madam. Because it was made clear, madam, while asking for the password, madam, it was made clear.
You must give a reason. Why? What was the purpose? If
Purpose,
you
madam,
had
would not be-
rejected, if you had rejected the bid,
madam.
what was the purpose of reopening a
No.
price bid which
We-
could not
we
be
did
opened in the
reject it
portal?
on 26 itself.
Unless, let us say, unless you wanted to see their prices.
We have seen the prices, NRL has seen
Then-
consultant has not seen, and the private respondent has also not seen the price.
Then some kind of evaluation was done.
No evaluation was done. No evaluation was done.
Yes.
But you will kindly come to page 167, ma'am. Fourth point from the bottom, ma'am. The BOQ template
Hmm.
must not be modified, replaced by the bidder, and the same should be uploaded after filling the relevant columns. Else the bidder is liable to be rejected for the tenders. Bidders are allowed to enter the bidder name and values only. My respectful submission is, the moment you have tinkered with the file, Because it is an admitted position that they have put a password.
No, but the fact that you have been able to open it subsequently belies your contention that on the date when you, no, no,
Now they provide the password, they can be opened.
no, it's not that. The question is, one can understand that when you wanted to open the file at the portal, could not be opened.
Could not be.
Therefore, their prices could not be viewed. Therefore, consequently, no evaluation.
No.
What you did was, on a subsequent date, you downloaded it, opened it.
Yes,
So the technical hurdle of whether it is a corrupt file or not a corrupt file, you have crossed it.
we are not on that. Because.
And it is your tender condition that this BOQ is not the final evaluation.
No, it is not the final event.
Therefore,
There will be loading factors.
therefore, once the prices were before you, you have to answer the question why the evaluation was not proceeded with.
Because the price bid has not been opened as per the tender procedure manual.
Then why open, why did you open it?
It could be a mistake on our part. But will it not overcome that? Will their mistake be condoned, madam?
No, it's not a question of mistake, it's a question of intentions. This is a contract.
My lord,
Parties are bound by the contract.
what is the part of the contract?
You have made us affidavit on oath to say that you can view the prices by downloading it.
We could view it, but the consultant could not view it.
The consultant could not view it, but you could view it.
We could view it.
Now there's a question of whether the evaluation is to be gone or not. You have rejected it on the ground that your prices could not be opened in the
Yes,
the
portal.
portal, and that you admit is not the final evaluation.
No, fine. That is a.
So the
step
purpose
up-
of the conditions of opening it in the portal is to have the figures before you.
Not only that, madam, transparency also.
Exactly. It is
Because
before
when the
you.
price bids are open, madam, everyone has to see, madam. Now the price of R4 is viewable to all. But his price bids cannot be viewed, madam, even today.
Okay.
My respectful submission, my interpretation which I have given, that it is a corrupt file because you have tinkered with the BOQ form, which you could not have done under the tender conditions. Now it is an admitted position, madam. At page 375, madam, it is admitted, madam.
Is it possible to view the files from their end? Is it possible to see their files? See their files at the portal from their end?
They will have to put the password.
No, madam.
What I'm saying is, once you upload the file in the portal, it is possible for the NRL to see it.
No,
No,
no. In the portal we cannot see.
no. For the other parties,
No, they
shortlisted
cannot.
party,
No,
who can view it?
no one can view it in the portal.
Then
That
How
is
do-
my point. That is, no one can view it in the portal. Only when we download the file in our system and enter the password, then we can view it.
okay. In the portal,
Not in the portal.
Then?
In our system. Now. From the portal, we have to download it on our computer and we can see. That is my specific.
and how did you open it on the next day?
Because we downloaded it. Now.
And why it was not opened in the
It
same
cannot be
process?
opened in the portal.
You have to make your stand clear. It is uploaded in the portal.
Yes.
You are saying that it cannot be seen in the portal by any party.
No.
It has to be downloaded.
Madam, I think they may be able to view, madam, if they put the password that I'm not sure. We cannot view without putting the password.
What password?
That password which they have put,
The shortlisted party did not put any password.
no, they did not put.
So what,
Their price can be viewed.
that is what I'm asking you.
Exactly.
At the portal, is it open to the NRL to view?
No. NRL can view only their price.
That's what I'm saying. You can view their price.
Their price.
Am I not audible properly?
Madam,
Am I not audible?
what should be audible?
So if their price bids were not password protected, then it was open to you to view both the prices at the portal itself.
Yes.
Okay. Now, is it possible for them to view their price at the portal?
I think they can do it by putting the password.
Correct, there is a query which they have made, and this was at least 213, maybe this might show some light, this is their affidavit, madam. At least one.
That is whether, with regard to whether the bid can be changed or not.
This is
That is not the thing, ma'am.
POQ template is uploaded only after password protected by the department to bidders cannot modify the BOQ and system.
No, that is regard to the changing the file number. We are not on that.
So there cannot be any.
And what is the learned single judge held?
Learned single judge has held that it is a mistake on their part. And there is no error in the decision making process. We have considered everything and that pre-playing the judge has to be given to us, the interpretation,
You considered everything means you rejected because it could not be opened.
it could not be opened. The findings start, my lord, the findings start at paragraph. Page 402, my lord.
Then this matter had earlier traveled to this court again, earlier.
And there was a mistake in the communication, my lord.
So,
For which we had also filed a review.
so when was their bid rejected, on which date?
It was rejected finally by the email. It was communicated
When?
to 120,
23.
23, sorry.
But learned single judge held it was rejected on 26 itself.
It does not say, so. It says that on 26th itself, there was a distinction brought in between the R4 and the petition.
Right.
Because R4 was earmarked as L1 manner, the petitioner's bid was declared to be defective manner. That is the finding.
All right. Yes,
19.4 manner.
anyone for the respondents?
Just before that, I will just clarify, I'm sorry by that. Page 331, your lordship will find that somewhere. That it can be comparative, since they could not open, later on they can download and upload it, and all parties will see.
Let me make my-
It will be regenerated. At page 331, the lordship find answer to question number 9.
Hmm.
Has your lordship got that? It
Yes.
says, the system generates the comparative chart from the BOQ uploaded by the bidders. If the bidder makes any mistake with the sheet name or any of the value, then the system will not be able to read the data from the BOQ uploaded, and hence they get missed out from the comparative chart. The department user may take a decision to accept or reject that depending on the nature of mistake and regenerate the comparative chart manually and upload this comparative chart along with the financial summary, which can be seen by the generator. This they did not do, my lord. This is what.
Lordship will kindly read it again, my lord. Lordship will kindly read it again. The system generates the comparative chart from the BOQ uploaded by the bidders. If the bidder makes any mistake in the sheet name or any of the values, then the system will not be able to read the data from the BOQ uploaded and hence may get missed out from the comparative chart. Lordship will kindly note now. The department user may take a decision to accept or reject that depending on the nature of the mistake. So that discretion is given to us. And this is only an FAQ manner. This is not a direction. This is only an FAQ manner and this the learned single judge has dealt with, manner.
Yes.
At page 403, manner, 19.2.
Yes.
In the frequently asked questions available at the e-procurement portal, question number 9 is to the effect that if after generation of the BOQ comparative statement, the data of one of the bidders does not get reflected in such generated BOQ comparative statement, what would be the option available for the tendering authority? As answer, it is mentioned that the system generates the comparative statement from the BOQ uploaded by the bidders. If the bidders make any mistake in the sheet name or any of the values, then the system will not be able to read the data from the BOQ uploaded and hence may get missed out from the comparative statement. In such situation, the department user, meaning thereby the tendering authority, may take a decision to accept or reject that depending on the nature of mistake and regenerate the comparative statement manually and upload such comparative. So the discretion is upon us, man. It does not say that we are bound to do it. And regarding the IE,
But the discretion must be used wisely.
exactly, man.
They can't
So
be.
first he has to show that he has to show.
Yes, for the respondents, who's there? What do you say? What is your status?
They have already invested before money.
Oh, money to, of course, you'll invest because you have come for contract.
Actually, you already placed a letter of intent on a.
Letter of acceptance will have been issued.
Yes, madam, he has started the work, madam, may I point out, madam, during the entire pendency of the writ petition, madam, there was no interim order of.
There was.
There was no.
Subsequently, we could see one.
Subsequently, madam, what has happened? On 30th of January, madam, that order is not before my lord, madam. What have you can?
Some order is available here.
No, madam. I'll clarify. On 30th of January, madam, an order was passed.
Hmm.
Where the interim order was rejected. And it was made subject to the outcome of the writ petition.
Correct.
Now, after the judgment was, case was reserved for judgment, madam. Because of the delay or whatever, madam, we had issued the work order. That was stayed. But finally, in the interim judgment, all earlier interim orders have been vacated.
So therefore, there was an interim order.
Only for the period from 13/6 to 27/6.
Right.
During the pendency of the writ petition, that is the order that I have placed. The interim order was rejected, declined, and it was made subject to the order.
So we'll have to hear the matter.
My lord,
And we'll keep it immediately after reopening. You tell us what date is convenient for all the parties.
After 19.
You can have it on 20 also. What documents are these? You bring it on record, whatever you want to bring it. You bring it on record, whatever you want to bring it, you bring it on record. You file it by way of an affidavit. You file it. We are not restraining you from filing it.
LOA stay order.
Just a minute. You can ask him. Yes, heard Mr. K. Goswami, learned senior counsel assisted by Mr. Swenson, Mr. A. Khanna. And for the appellants, Mr. N. Deka, learned counsel appearing for respondent number. Respondent number,
I am too much.
respondent 2. Respondent number 2, Oligo Refinery. Who's for 3? Who's for 3?
Bimal Shetty was appearing.
Okay.
He is our consultant.
All right, none appears for 3 as on
But
date.
notice has not been issued, man. We are on carrier.
That's right. Mr. B. Sharma for respondent 4. Respondent 4. Here I would caveat as well. Both, I think there are 2 caveats, one by NRL and one by them. Okay. Heard caveats, learned councils, caveat discharged, both the caveats. This appeal is directed against the judgment and order dated. (270623) passed in WPC number 96 of 2023. The appellant before this court was one of the bidders in respect of a tender invited by the respondent number 2, NRL, being NIT number, NIT bearing number so and so, dated 25/10/2022. For supply of reactor and regenerator package for PFCC unit as per technical specifications for Numodigor Refinery Limited, Assam, India. The NIT was a open global tender basis under a single stage 2 bid system. Within bracket part 1, techno-commercial bid, within bracket unpriced bid, and part 2, price bid. So in response to the same, NIT invited by the respondent number 2, the appellant as well as the respondent number 4 submitted their bids. Also, both the bidders were found to be responsive in the techno-commercial evaluation. What is it? Techno-commercial
Techno-commercial.
evaluation. Full stop. Subsequently, when the price bids were opened on 26/12/2022, the price bid of the respondent number 4 would be open. However, the price bid of the appellant would not be open as it was found to be password protected. Full stop. In terms of the NIT, a computer generated / system generated BOQ statement was to be generated upon opening of the price bids. Full stop. As a consequence of the price bid of the appellant, as a consequence of the price bid of the appellant, which could not be opened, the BOQ system generated statement revealed the details only with regard to respondent number 4. Insofar as the appellant is concerned, the particulars of the price bid and the items were not reflected. Full stop. Being agreed, the appellant as a writ petitioner approached this court by way of filing WPC number so and so 96 of 2023. The matter was heard, and the learned single judge, by judgment and order dated so and so, dismissed the writ petition. By holding that there was no infirmity in the decision-making process, as well as in the decision to reject the price bid of the bidder of the petition, within bracket, the appellant herein. The writ petition was found to be devoid of merit and was accordingly dismissed. Most of the agree, the present writ appeal has been filed. Also, the learned senior counsel for the appellant strongly urges that the BOQ system generated statement of the price bid of the bidders is only a formality which is to be undertaken by the employer, and thereafter a proper evaluation as per the evaluation criteria mentioned in the NIT was required to be followed. Full stop. However, the NRL refused to accept the price bids which were uploaded by the appellant, and because the same could not be opened in the portal, as the same was stated to have been password protected, rejected the claims of the rejected the bid, the appellant. Full stop. Learned senior counsel submits that this is contrary to the provisions or the clauses of the NIT, in as much as the BOQ system generated statement cannot be the basis for evaluation of the responsiveness of the tenderers or the bidders. Also, there is a detailed procedure laid down under what clause?
So, F1H
F1H,
and F1 triple B.
F1 triple B, F1 within bracket triple B,
Yes,
F1 within bracket triple B, by which the evaluation ought to have been done by the employer, namely the NIT, NRL. Full stop. That having not been done, the entire process of holding the R4 as the L1 bidder is contrary to the specific provisions or the terms and conditions of the NIT. Full stop. The further contention of the Learned Senior Council is that there were certain communications between the NRL and the appellant in response to, in respect of the password protected, in respect of the process for opening the price bid of the appellant, full stop. The password was subsequently furnished by the appellant, and in the affidavit, in an affidavit filed before the Learned Single Judge, there is an averment that the NRL had been able to open the price bid of the appellant on 27/12/2022. Full stop. If that be the case, then the appellant was duty bound to follow the procedure prescribed in the NIT for evaluation of the price bids, and thereafter declare the L1 bidder, instead of forthwith rejecting the bids of the appellant merely on the ground that their price bids on the online portal could not be opened, as it was stated to be password protected. Learned Senior Council submits that the Learned Single Judge failed to appreciate these factual issues and came to a conclusion that there was no infirmity in the decision-making process and thereby dismissed the petition. It is submitted that these issues not having been dealt with in the manner required to be done, the impugned judgment and order needs to be interfered with, set aside, and appropriate orders be passed by this court. Yeah. Mr. N. Deka, Learned Council appearing before the NRL, however, strongly disputes the contentions of the Learned Senior Council. He submits that as per the NIT, all bids are to be uploaded in the portal without any change in the format. Also, the appellants were required, the bidders were required to upload their bids in the portal and make it password protected only in respect of techno-commercial bids. Full stop. However, in respect of price bids, there was no specification that password protected files were to be uploaded in the portal. Full stop. The Learned Council for the NRL submits that there is no infirmity in the decision-making process, as the system-generated BOQ statement in respect of the appellant could not be generated, as their price bids uploaded in the portal would not be open as it was password protected. So, Learned Council further submits that in spite of the passwords being entered into upon receipt from the appellant, the same could not be opened in the portal. Full stop. Mr. Decker, however, fairly submits that the department had downloaded the sale price bid and thereafter were able to open the price bid of the appellant. Full stop, however, but it is submitted, however, that by itself would not grant any right or privilege to the appellant in as much as even today the price bids of the appellant would not be opened in the portal. That's your scan. Full stop. He therefore submits that there is no infirmity in the judgment of the learned single judge, and the appeal, being devoid of any merit, should be dismissed. Yeah. Mr. B. Sharma, learned counsel appearing for the caveator, respondent number 4, submits that letter of acceptance has already been issued on 8/6/2023, and they have already made huge investments in mobilizing the machinery and personnel necessary for execution of the contract. He therefore submits that the respondent 4 being declared to be L1 and the letter of acceptance being granted on so and so date, no further cause needs to be determined in the appeal, and the same should therefore be dismissed, as the learned single judge has elaborately discussed with reasons as to discussed with reasons and has arrived at the finding that there is no infirmity in the decision-making process adopted by NRL. Well, learned counsels for the parties have been heard. Pleadings on record have been carefully perused. It is seen that learned single judge has held that a distinction has been drawn between the petitioner, between the appellant and the R4 on 26/12/2022, when the NRL could not open the price bids uploaded in the portal insofar as the appellant is concerned. And in the in the system generated BOQ statement, the particulars in respect of the price bid uploaded by the appellant are not reflected. Full stop. Learned single judge held that in terms of the contract, there is an option given to the employer to accept or reject such a tender, and they having decided to reject the tender, the decision-making process could not be faulted with. Better. This court has also taken note of the order passed in writ appeal number 13 of 2023, dated 25/1/2023, where at para 7 there is a finding by the appellate court that the bid of the appellant therein, and who is the present appellant before this court, was rejected only on 2/1/2023. Full stop. this view is also not disputed by the NRL, in as much as they submit that the bids of the appellant was rejected by which order? A communication page.
2-1-23.
No, where is the page? Page number
71.
7-1.
7.
By the email. Is it by the email?
Right.
Was rejected on 2-1-2023 by way of an email. Whereby the appellant was informed that their price bid would not be considered for further evaluation, as the contents of the price bids are not viewable without login credentials. Full stop. The question before this court in the present proceeding is whether the failure of the NRL to open the price bids in the portal, because the price bids of the appellant in the portal, because the same was stated to be system generated, can be rejected on the ground that it was a corrupt file, corrupt form, or can be construed to be in a form, format different from the format which is available in the tender documents and the clauses mentioned therein. Also, the further question before this court will be whether, on the basis of the system generated BOQ, whether the contract can be finally evaluated, or is a process of proper evaluation by following the evaluation criteria is to be resorted to by the NRL, more particularly in view of their statement that the price bids of the appellant would be subsequently opened on 27/12/2022, as had been averred in their additional affidavit before the learned single judge. So, be that as it may, these questions will require consideration. Therefore, at this stage, this court proposes to issue notice to the respondents, making it returnable after 2 weeks. And since the learned counsels in respondent number 1 and who's for the 1?
Union of India.
Union, okay. 2 and 4 are represented by their counsels. Notices are waived. However, extra copies be furnished within a period of 1 week from today. Let notice be served through the DSGI, Guwahati High Court, in respect of Union of India, respondent number 1. Let notice on respondent 3 be served through registered post area. In the meantime, the further steps in respect of execution of the so-and-so contract shall remain stayed till the next date fixed. As agreed to by the learned counsels, that the matter be listed for hearing on 20/07/2023, on which date an attempt will be made to dispose of the appeal.
That causes serious prejudice to the project will make it subject to the outcome. So
They have
that,
a part-heard manner because the lordship acquired the third.
because that causes serious prejudice to us.
Expedition on that basis.
The entire project gets stalled. Will kindly consider. Because if I rely upon that NG project judgment, because this is, what you will kindly consider, this is the expansion of the refinery project, it has already been delayed.
In fact, your lordship is only continuing the interim order which we have got during the, because that order your lordship will get
Lordship is-
I that I have filed.
That order dated 31, that is before the lordship.
In that I is 36/23 order. I 1916. 1916. Page 30, your lordship will get this order, 13/6/23.
That was only for a limited period, from
Paragraph
36.
4, your lordship will see. Starts from 4 at least 14. The last line, such obtaining tax equation, this court is of the considered view that the respondent NRL authorities shall not take any further action on the basis of such LOA. And ultimately,
This interim order is granted by this court in view of the fact that the learned single judge. Where is that order?
page 13, my lord.
Learned single judge by order dated 13/6/2023 in IA number 1646 of 2023. Had stayed. Had restrained the
Last slide.
respondents from taking any further action on the basis of the LOA issued to the respondent number 4. Full stop. This order came to be vacated only on the delivery of the judgment, an order which is presently under appeal and which was delivered on 27th.
27. 25.
So in that view of the matter, this court is of the view that the interim order is directed, will continue, will remain till the next date of hearing.
Keep your life.
Let us see.
Difficulty is that the entire process gets stalled.
It-
From 30
That process could not have started from 27th.
It had started, madam. From
What
eight-
extent?
eight It had started, madam. Interim order was passed only on 30th. madam.
Correct?
From January, madam, there was no interim order.
You did not go and appeal against that order.
Which order? madam? They went, madam.
They went in a
We went, madam.
You went.
Next page, next page.
And then it was- All right, all right.
Keep your life. Part-heard.
Not partner. How can it be partner? Unless you want the court not to reopen and be on vacation forever.
Keep your.
It'll be before the regular bench.
Item number 2,
Yes.
Where is the lawsuit for 11 senior staff? Lawsuit, the member has become infra.
Infra-
Tender has been cancelled.
Cancel.
Last night I got. No, I have given them minute for lawsuit, it's so that all the technical, all those details were found non-responsive in the technical.
The entire tender is cancelled, including the additional clause. They must have contemplated that Mr. Bhattacharjee will appear for the appellate.
One thing is that this petition was filed before the meeting was opened. Because there is a clause which according to us very exorbitant and the local person will be declined. That clause remains in this company, we have to challenge it again.
That will be subject to such tender being floated with such condition, not condition, be open for you to come back. If that condition remains.
Any of them.
Otherwise, if the tender has been withdrawn, then nothing remains.
Because logic will find in the minutes of the technical evaluation held on 4th July. A lot of all the readers were found non-responsive.
No, whatever, but if we close this, then we have to give them liberty because the order of the learned single judge remains.
Because it's
still remains, because in subsequent tender, whatever they may float, okay, there may be new conditions.
We don't know. We are saying that there is a finding by a learned, by a single judge of this court. Agreed, they have come before this court in appeal. Now, if this appeal is disposed of as infractions or withdrawn as not pressed, the order of the learned single judge will remain. So therefore, unless we give liberty to come before this
Lordship,
court.
it's always there, Lordship. But Lordship has not to be any specific.
Yes, what do you say?
You know, that will be a problem, but you don't see kindly city in the.
Sorry, the what order?
Page 292. Very. Part 3 Board of Government, learned counter for the petitioner who has put to challenge the insertion of tender condition with regard to the original 90 dated spend. The contract in question is with regard to supply of Napier steel, and in the NIT dated spend, 9 conditions were given as qualifying criteria. The case projected by the petitioner is that it fulfill all the 9 criteria and was eligible for participation. However, when the include original, that is to a new criterion has been introduced with regard to the annual turnover. As per the state criteria, bidder is required to have an average annual turnover of ₹4 crores in the preceding 3 years. The case of the petitioner is that thus insertion is absolutely unreasonable and arbitrary without having any nexus to the object to be fulfilled, and has been introduced only to limit competition. On the other hand, the B should learned Candy Council Department has submitted that the contract document itself empowers the authority to amend the bidding document, and in its correction, he has referred to the clause 8 of the check. He further submits that the requirement is not relevant in support of his submission. He has placed reliance on the it is issue notice retardable on 4-5. Sri Sauduri has learned standing council, agriculture department, except notice on behalf of the their executive of the petition be served upon the month. Heard the learned council interim fair. The Buraga learned council for the petition that has submitted that if in the meantime the tender process is about to be gone ahead and finalized, the entire case petition would become infructuous and the further it submit that the final certificate is set up. It is also the learned council for the petitioner that the similar method pertaining to the supply of hybrid made an interim order was recently passed as a court. After hearing the party, though the court is not inclined to pass a blanket order of stay, it is directed to behold the fact that the petitioner has not fulfilled the requirement of the new criteria instead of the amendment that is when the petitioner will be allowed to submit his fee, which may also be open along with the order qualified. However, no final order of allotment is issued till the next day. In the matter pertains supply of goods, it is public for them, let the instruction be produced on the next day, which is based on both sides. In the meantime, the financial each of the parties are open. The same may be produced before this court. They still govern. It has been done. They say that non-response. It should have been produced before the court.
But it is open to them to withdraw. Is there a bar How does the interim order bar them from,
That is not bad,
uh,
but they should have produced.
they should have, but they decided not to.
Now, they said they have opened it. Why they should violate the court system?
Lordship, the technical bid was open. The court's interim order was that if financial bid is open, then it should be kept in a seal cover. Lordship's technical bid was open, thereafter their evaluation process is there, Lordship. And in the minutes, Lordship, you will find. the reason
So
for
let
it.
us, if it is not there, then we should close it, Mr. Bachari.
But the order. Judgment stand.
Now, judgment stands will give you liberty to come back in the event such a condition is there or not there, that will have to be dealt with. When the tender is there.
Because in subsequent logic, the bid, the amount quantity may be higher also. Lordship.
We don't know.
It may be in the initial NIT also.
Then in the.
We don't.
Only thing that there is some protection to be given. That they cannot take advantage of the judgment. Inquest.
No. What does the judgment say insofar as you are concerned? It merely says that your grievance of adding the new condition has not been accepted by the learned single judge. Court is of the view that it is within the parameters of the.
Single judge has rejected that. All complaint. Yeah, he did that.
Yes, we have this judgment, but para 12, I think, para 12.
It could be full confidence.
Hmm.
One is that they did not disclose the value of the in the tender. Subsequently, in the affidavit, they have said which has the interconnection with the submission. Oh, yes.
No, so we are closing it, giving you liberty to file any appeal or any writ petition insofar as the new tender that may come. If you have any grievance,
So you know,
supposing your grievance was that turnover clause of 12 crores or something was added subsequently, which according to you was not a necessary condition and which debarred you from participating. And there was a very short duration in which you'll have to supply and those leap years. So now all these issues are not required to be looked into for the simple fact that they have withdrawn. They have not decided not to go ahead with the tender. So as and when the new tender comes up, if there is any cause, you are free to approach this court.
I think that there is a technical point.
Which is,
They said they did not mention anything about it. Now. Indian Act. Now India affidavit, they say it is 13 crores, 11 crores. That creates problem for litigants. How do I affidavit takers? I will take into account that amount of money. And then I. What is
but all these will, is it open for a writ court to tell them how they should, what conditions they should have in a tender, which is yet to be floated?
No, not condition. I am saying, they did not disclose the amount. Below of the. That creates problem for us. Now it by way of, and it will be a very health precedent, by way of. If it is a file, and there is a decision, and then how can I measure my income, annual income?
That's okay. Now these things are irrelevant in the face of the department withdrawing the tender itself. You will have to wait for a new tender and new conditions, same conditions or new conditions may be there. Heard Mr. A.K. Bhattacharya, assisted by Mr. H. Borgwine, learned counsel, appearing for the appellant, Mr. B. Chaudhary, appearing for the respondent state,
Agriculture department. All
agriculture,
all the
all respondents. This appeal was directed against the judgment and order dated Tuesday 06/2023 passed by the learned single judge in WPC number 2215 of 2023. Posted by the impugned judgment, the writ petition referred by the present appellant as a writ petitioner was dismissed as being devoid of any merit. Full stop. The para, today when the matter is listed before this court, Mr. Chaudhary, learned Standing Council Agriculture Department has furnished a cancellation notice issued on 7 July 2023. Whereby the tender for supply of Napier slips hyphen Kharif season by tender number so and so has been cancelled. So by the same notice / corrigendum, it is mentioned that the tender has been cancelled because of administrative reasons or issues. Full stop. The said notice also contains a minutes of the meeting of the bid evaluation committee held on 4th of July 2023. Insofar as the minutes are concerned, in terms of the minutes, it is seen that there are 6 bidders who responded to the bids invited by the Agriculture Department for supply of Napier slips. Full stop. From the comparative chart indicated in the minutes of the meeting, it is seen that not a single tenderer has been found to be technically responsive. Under such circumstances, the tender evaluation, bid evaluation committee recommended cancellation of the tender. Full stop. And accordingly, the notice dated 7 July 2023 was issued whereby the tender has been cancelled. Para. In view of such specific statement and a copy being furnished before this court, which is kept on the case report, this court is of the view that this appeal can be closed as not pressed. However, giving liberty to the appellant to approach this court if any such cause arises, any such cause survives, pursuant to such tenders, fresh tenders, as may be furnished, as may be issued by the department, or any such procurements. Full stop. With the above observation, you want to withdraw or we dismiss it? That's right. That's what we have said. So in that view of the matter, we'll dismiss it as infractuous, or you want to withdraw it? In view of that matter, the appeal is closed as being infractuous.
Lordship, the liberty may be only in respect of the product in this tender. Because otherwise, Lordship, they will try to influence the other tender. Only in respect of if they the authority decides to reflow. Only with regard to this.
No, for future, is there any liberty necessary? Your liberty is available to you.
Only that.
Sorry.
He said that we believe that That clause which we have started, only that will be able to challenge. We do not know what condition they will give.
No. What are you submitting?
Liberty may be granted only in respect of if the authorities decides to refloat again for previous years. Lordship. Otherwise, they will continue to use that for other purposes also. Lordship. All lordship, liberty is not required. If they are agreed.
No, liberty is necessary because tomorrow if you decide to refloat the tender again, then what happens?
That's why lordship may be specific with regard. to
In
this
respect,
item.
the liberty is granted
Otherwise,
to
they will
approach this court in respect of the so and so tender which department submits has been cancelled by notice dated so and so. Disposed. Yes.
There was pertaining to the fair which you can pay regarding that it will not be affecting other items. While we are submitting and paying for this food. In a similar case on the very day when this matter also came up, they came with the same minor instructions that the items that was challenged, that is petition 760 that was made, very similar clause was challenged, my lord, they came with a minor instruction that these can make it over.
Mr. Borgohain, see, these are all matters of interpretation. If they want to subscribe to this clause, you are at liberty to, your options, your remedies before the court of law are open. What we are saying is, if they tomorrow decide to refloat this tender, then you are at liberty to approach this court again and challenge it. This is one. Number two, if they decide to float a fresh tender with the same clause, what you should do is available before you. We are not foreclosing that.
But we have a hurdle man in respect to the judgment passed by the single judge. We have this hurdle because every day he will come with the same judgment tomorrow and say that this matter has already been decided on this issue of turnover criteria, my lord. That is a difficult matter.
So then we'll decide it as and when it comes up, it will has to be decided. Today, how do we decide on a matter where the tender itself has been cancelled? What is to be decided? For what benefit?
If you not put it to point one, consumption. The contention raised by the applicant will not stand in view of the case.
Contentions raised by the.
Will not stand in view of the case.
We write one line that in view of the cancellation notice, the grounds urged in this appeal need not be dealt with at this moment.
Okay.